Hello, everyone. My name is Tarun Thavanchran, and along with my friend Jonathan Zhu, we will be talking to you about consumer protection in the Canadian legal system. We hope you enjoy. We are all consumers. We consume goods and services every day. As consumers, we are protected by the Canadian Consumers Protection Act. What is the Canadian Consumers Protection Act? How does it apply to your daily lifestyle? How are you protected in Canada? Here is a brief video to answer all of your questions. Now, let's discuss the history of consumer protection. Until the 18th century, the consumers had to verify themselves the quality of the goods they purchased, and only in presence of gross negligence the seller could have been held liable for their product. The struggle against capitalism and food fraud started the first phase of consumerism, but it wasn't until the third phase in the 1950s that we saw the involvement of the European countries. The first consumers' organizations were born in Denmark in 1947 and in Great Britain in 1955, where the government created the Consumer Council in order to enable consumers to express themselves on issues reserved to producers and traders. But the real normative breakthrough came with the Single European Act. It modified the Treaty of Rome by strengthening the role of the Economic and Social Committee, to whom were attributed powers to protect the consumers. Over the years, some important changes were made to the above mentioned legislation that paved the way for a wider consumer policy. But despite these additions, it still lacked a solid foundation that allowed getting a real consumer protection.
So then how does the government restrict business owners? Well, there are a number of things that governments do to restrict business owners. One example is restricting the material that business owners use to create their products. Some materials are deemed unsafe to the public. Some metals may cause products to be deemed unsafe. Thus, the government will restrict some materials in productions. Another thing that governments restrict is the waste that owners produce. Owners must limit the amount of waste that they produce. Owners must also be careful about how eco-friendly the process of production is. The last thing that government does to restrict business owners is by taxing owners. The tax is usually based on the amount of money the businesses make, and the more money they make, the heavier that they will be taxed. So then what type of laws are involved with consumer protection? Well, there are many laws that are involved with consumer protection, although the two important ones that will be discussed is the Consumer Protection Act and the Consumer Packaging and Labeling Act. So, to start off, the Consumer Protection Act, information on product safety. This is where business owners must inform consumers of dangers of their product. Business owners must also inform consumers how to handle their products safely to ensure that they don't endanger themselves or hurt themselves. There is also general prohibition. As said on the previous slide, the government will prohibit or restrict some general things. The last part of the Consumer Protection Act is packaging and labeling, where business owners must include some sort of labels to inform consumers of potential dangers and how to handle their products safely. With this in mind, we move to the Consumer Packaging and Labeling Act. This act prohibits false and misleading representations relating to packaged products. All information on a package must be neither false nor misleading to the consumer.
Objects of Consumer Protection Act, its extent and exceptions. Let us now understand the objects of Consumer Protection Act 1986. Objects of the Consumer Protection Act. The objects of passing the Consumer Protection Act are clearly stated in the preamble of the Act. It says that this Act is basically passed to protect the interests of consumers. Provisions for setting up of a mechanism to solve consumers' grievances are provided through this Act. The Act seeks speedy and simple redressal to consumer disputes through quasi-judicial system set up by district, state and national levels. The quasi-judicial system is expected to observe that the natural justice is provided to consumers. These judicial bodies also have powers to relieve a specific nature and to compensate the offended consumers. Let us take a quick look at the extent of Consumer Protection Act. Extent of Consumer Protection Act. This Act extends to the whole of India except the state of Jammu and Kashmir. It has authorized the central government to make different provisions of the Act applicable from different dates for different states by notification. The Act shall apply to all goods and services. Let us now go through the exceptions of Consumer Protection Act. Exceptions of the Consumer Protection Act. The Consumer Protection Act has few exceptions. These are the areas which have been excluded from coverage of the Act. First, free services like free libraries and free medical services. Second, the services provided in the form of contract, for example, services of maid servants or domestic servants. Third, the services of doctors in government hospitals. Consumer Protection Act or Amendment Ordinance was passed in 1993 to cover up the loopholes in the Act of 1986. The amendment brought unsafe goods under the coverage of the Act. To summarize, consumer is one of the important components of the economy. He is one of the participants in the process of production. A consumer plays a pivotal role in the economy from both the sides, demand and supply. The Consumer Protection Act 1986 was enacted with the object to protect the interests of consumers at large. The Act intends to seek speedy and simple redressal to consumer disputes through quasi-judicial machinery set up at the district, state and central levels.
Now, let's discuss some famous cases of consumer protection around the world. The first case is New India Assurance Company Limited versus Abhilash Jewelry in 2009. The complainant/respondent, who had taken a jeweler's block policy, lodged a claim with the opposite party insurer of loss of gold ornaments. The insurer repudiated the claim on the ground that the loss occurred when the gold was in the custody of an apprentice, who was not an employee, because the policy stipulated that for identification of the loss, the property insured had to be in the custody of the insured partner of his employee. The National Commission allowed the complaint, holding that an apprentice was an employee, since Section 2(6) of the Kerala Shops and Commercial Establishments Act defined an employee to include an apprentice. The Supreme Court, however, held that the word employee in the contract of insurance mentioned had to be given the meaning in common parlance. The definition in the local act including an apprentice in the category of employee was only a legal fiction, which is a concept in law and cannot be applied to an insurance contract. The court therefore allowed the appeal. The next famous case of consumer protection is HDFC Bank Limited versus Balwinder Singh. The complaint was of the bank or its loan recovery agent employing musclemen to take forcible repossession of repossessed cars, and thus causing physical harassment and mental trauma to the complainant. The district forum allowed the complaint and directed the bank to pay compensation of 4,000 lakhs in rupees for repossessing the vehicle in this manner and reselling it to a third party. The State Commission confirmed the order in appeal, dealing with the bank's revision petition. The National Commission expressed shock that the bank had hired musclemen directly or through its recovery agents to recover the loan repossessed vehicles. The Commission had also referred to the State's Commission order, which had observed that the alleged letter produced by the bank purporting to the complainant voluntarily handing over possession of the vehicle was unreliable, and that no notice was given to the complainant at the stages of repossession and sale of vehicle. In dismissing the petition, the Commission relied upon its judgment in City Court Maruti Finance Limited versus S. Vijayalakshmi, where it strongly depreciated such practices. The Commission dismissed the petition and awarded 25,000 lakhs in rupees as exemplary costs in this case.
So then how would the right wing look at consumer protection? The right wing would want to put less restrictions on business owners. They want the business owners to do whatever they want freely. They want to have less taxes placed on business owners and allow business owners to do much more. The right wing see it as the consumer's fault if they are hurt from the products. If you decide to buy a product for say $2 and the product suddenly catches on fire or explodes, then it is the consumer's fault because they are getting what they paid for. They paid a cheaper price for a greater risk. The right wing sees it more as the consumer's fault and less as the owner's fault in many situations. Now, as for the left wing, they see it as the complete opposite as the right wing. They see it more as the business owner's fault than the consumer's fault. The left wing strongly believe in a strengthened consumer protection plan for Canadians. This means more restriction on business owners and more taxation on these business owners. The left wing truly wants consumers to feel as if they are safe from millionaires who don't truly care about the public. They want to protect the public as much as possible and keep them out from danger and harm.
And on that note, that concludes our presentation. We hope you enjoyed our presentation on consumer protection. Remember, you as a consumer have your rights under the Consumer Protection Act. Happy shopping!